Have you ever wanted to know what provisions you need in an assignment agreement? Have you ever wondered what other provisions you may want in your assignment agreement? Have you ever wanted to know how to explain to a weary seller what some of these provisions mean? If so, stay tuned for all that and much more.
Hi, I'm wdolan, and this is Esquire Advice, where we explain complicated and lucrative real estate and business topics. Remember, we are not forming a lawyer-client relationship by way of this channel. Always consult your local attorney before taking any action. With that said, grab a pencil and a piece of paper and get ready to learn.
Welcome to our episode on assignment agreements with a special emphasis on the assignment agreement that I use with my investor clients. However, before we dive in, please kindly hit those like and subscribe buttons so we can keep bringing you valuable and profitable content. Okay, a well-drafted assignment agreement with investor-friendly provisions is a document that looks different than the ones you would likely obtain from another investor or from the internet. From the lawyer's perspective, every transaction can have different facts or issues, and states have different laws, and each of these reasons could create the need for customizing an assignment agreement. When I created my assignment agreement, which we are going to review in a moment, I worked with several of my highly experienced and respected investor clients to craft many of the provisions in a way that worked for them to get deals done, but still includes the protected provisions that lawyers want to see in an investor agreement of sale. Okay, so generally an assignment agreement must at a bare minimum be in writing, identify the assignor and assignee, signed by both parties, adequately identify the property, include the purchase price, the term, and potentially condition of title. Okay, so let's discuss my Delaware assignment agreement. Okay, so you will notice the title of this document is Assignment of Purchase and Sale Agreement. Now remember, purchase and sale agreement is a synonymous term with agreement of sale, so don't get too jammed up. However, if you're using this document with an agreement of sale that is actually titled agreement of sale, you're going to want to change this title. If you're using it in conjunction with my purchase and sale agreement, leave it just as it is. Okay, so the first paragraph we're going to see is going to cover a lot of those minimum requirements that we just talked about. It's going to catch the date of the document. It's going to catch the names of the parties. You'll notice here that when we describe the parties, we're assuming that the assignor is going to be a limited liability company. And in this case, because this is a Delaware agreement, a Delaware limited liability company. So if it's not, then you're going to need to change this. If it's a person, you're going to need to change this to an individual. If it's a Pennsylvania limited liability company, you're going to need to change Delaware to Pennsylvania. If it's a corporation, you're going to need to change the word limited liability company to corporation. You also need to change the designator, which is that LLC after the blank on the second line of that first paragraph. You're going to need to change that designator to whatever the applicable designator is. If it's a corporation, it's probably going to be Inc., Corp., Ltd., something like that. Even if it is a limited liability company, LLC is not the only designator, right? So you have to make sure you have the appropriate designator listed. Same thing for the assignee. We're assuming that it's a sophisticated real estate investor and they're probably going to be using an entity. That's why we have two lines, or two blanks rather, on line 3. You'll notice the first line, you'll see and blank. That would be, and ABC Real Estate LLC, comma, a Delaware Limited Liability Company. Again, you need to use the applicable type of entity, put the correct party's name in there, but that's how you would complete that section. Under the recitals, we're describing what is happening in this transaction, that there is a purchase and sale agreement between a seller and a buyer, and that buyer under that purchase and sale agreement is the assignor in this agreement, and that the assignor is going to assign its interest in that agreement over to the assignee. And this is an important part of this agreement because it explains the context of what's happening. So if you don't have this and somebody picked up this document and read it, they really wouldn't understand what the nature of the transaction is. So this is a critical building block of this document. It also captures this purchase and sale agreement. It captures the defined term. It indicates that it's going to be attached as an exhibit, which I think is the right way to do this so that it's clear what agreement's being assigned. It's also clear that both parties have had access to the document, they've seen the document, they know what terms are in that document. So it eliminates some potential deficiencies or arguments of parties trying to get out of that agreement down the road or trying to get out of this agreement. Okay, so in the agreement section, we're going to see number one is the agreement to assign. This is important and gets missed in a lot of documents that I see investors bring to me, and presumably they got it from the internet and it was probably either drafted or amended by a non-lawyer, right? But you do need to actually explain what's going to happen, that the assignor is going to assign the purchase and sale agreement, the assignee is going to accept that assignment, subject to payment of the purchase price and the terms and conditions of the assignment agreement, obviously. Section 2, the purchase price. This gets people really confused. Oftentimes I see people put the purchase price in here, which is the purchase and sale agreement purchase price. So let's use an example. Let's say in your purchase and sale agreement, the sales price is $100,000. And let's say you're going to assign it for $5,000. The number that goes in this blank is $5,000, right? So the blank in section 2, line 2, where it says the assignee agrees to pay, and there's a blank line there, you would write out 5, F-I-V-E space T-H-O-U-S-A-N-D for 5,000. And then on the line immediately below that, where you see the dollar sign in a blank, you'd write the numeral 5,000, and we already have the decimal point 00 for the cents included. So again, this is the assignment agreement purchase price. This is an important distinction. I can't tell you how many assignment agreements I have seen that don't even list the consideration. If you don't list the consideration, you don't have an agreement for what the consideration is, and it wouldn't be enforceable, right? Because there's no way for anybody to know because you didn't include it on the document. I'm also going to take a moment here to talk about the difference between a double close and an assignment or a wholesale deal. Because I see so many times I ask for an assignment agreement and I will get a purchase and sale agreement where the buyer who's going to buy from the actual current seller enters into a new purchase and sale agreement with the next party, right? You can do it that way, right? You can close and take title from the seller, and then you can turn around and sell and have another closing and have essentially two separate transactions. You certainly can do it that way. That's a double close deal. Now in Delaware, to do a double close deal, you have to, the A to B transaction, you know, from the seller to the investor buyer, the first one, that buyer has to come with his funds. And on the B to C transaction, that buyer has to come with his funds. There has to be two separate closings, two separate sets of funds. You can't use the funds from the B to C deal to fund the A to B deal. You know, I actually think you probably shouldn't be able to do that in any state. You definitely can't do that in an attorney state, because mechanically what would be happening is the attorney would be borrowing one client's funds, C's funds, to use to fund B's deal. Attorneys can't do that. We can't borrow one client's funds for any reason. Not to fund something for ourselves, not to fund something for another client, not to fund something for charity. Absolutely under no circumstances can an attorney borrow a client's money. Can't happen. There has to be two separate sets of funds. That, my friends, is the reason why a lot of people will use assignment deals, because they don't have the funds to do the A to B closing, right? B doesn't have the funds a lot of times. The other reason is that the closing costs are a lot higher if you actually take title and close, because you got to pay transfer taxes and title search and title insurance and attorney closing fees and recording fees and all of those items. And then you're going to turn around, whether it's the same day, the next week on a double close deal, and you're going to incur a lot of costs again. You're going to incur the transfer taxes yet again. And so between the costs and the funds, a lot of investors will use assignment agreements. But what you're doing in an assignment agreement, B, right, is you are assigning your rights under the purchase and sale agreement to someone else, in this case C, so that C can close on your purchase and sale agreement. C doesn't have a different purchase and sale agreement. C steps into your shoes in your purchase and sale agreement and closes based on the terms and conditions in that purchase and sale agreement. The assignment agreement that we're talking about in today's video is where you, B, are assigning your rights under the purchase and sale agreement to C. So this is a separate agreement, right? It's a separate deal. C is going to buy your rights under the purchase and sale agreement, and there need to be terms and conditions for that. Is there going to be a deposit? Is there going to, what's the purchase price going to be? What happens if the seller under the purchase and sale agreement can't deliver clear title? We're going to talk about some of these terms in just a moment. Okay, now that we have that straight and everybody understands the difference between a double close and an assignment deal, let's dive into section 2A and 2B in a little bit more detail. So section 2A says if the assignee does not close on the property because the seller cannot deliver good and marketable title to the assignee by the closing date, and the assignee terminates the purchase and sale agreement, the assignee shall not be required to pay to assignor the purchase price. This makes sense, right? I think this is everyone's expectation when you walk into an assignment agreement deal, that C is not going to be responsible to pay B anything if the seller, who's A, if the seller can't deliver clear title, right? There's no deal if there's no clear title. So I don't think there's anything controversial there, but we do include this provision so that it's understood and it's not just an assumption or a handshake deal, because when transactions go wrong, it's a problem if it's not in writing. Otherwise, the assignee's obligation to pay the purchase price of the assignor shall not be contingent on the assignee purchasing the property from the seller. This is a term that I like. I don't see this included in a lot of transactions, but what this does is it establishes that as long as the seller can provide clear title, as long as there's not a title issue, then B could actually enforce this agreement against C. So that if C just says, you know what, I woke up today and I just don't feel like doing this deal anymore. Or, you know what, another deal came along, it was better, I decided to do that one, I'm not doing your deal. Whatever the case is, if C is not able to close or decides not to close for whatever reason, but the seller was able to convey clear title, then B will have recourse against C. Now, maybe in an assignment deal for a purchase price of $5,000, maybe it's not worth it, right? But if the assignment fee is $40,000, $50,000, $80,000, I've seen them, they happen. It may actually be worth it for B to go after C, especially if the deal falls apart and B loses the deal with A, the seller, right? If the closing doesn't occur and the seller says, okay, you didn't close in a timely manner, we're terminating the agreement and we're going to move on. All right, well then B, if the assignment fee was $40,000, B's out $40,000, the property's gone. B can't even assign it to someone else. So B now could have recourse against C to collect, in that case, on the $40,000 assignment fee. So let's look at 2B. If for any reason the seller is unable to deliver good and marketable title to the assignee by the closing date identified in the PSA, assignee shall, in its sole discretion, have the right to terminate this agreement. Upon such termination of this assignment, all right, title, and interest and estate in the PSA shall revert to the assignor. Okay, so we got two different things going on here. One, we're just establishing the clear right that was sort of inferred or implied in the prior provision. that the assignee has the right to terminate this agreement if the seller can't deliver clear title, which makes sense. Again, I don't think that's anything controversial from either side. But then it also goes a step farther and includes another important provision that says that then the right title and interest in the PSA reverts back to the assignor. So what's important about this is when deals go south, there tends to be a lack of clarity on who has the right to the contract still, right? If there's a title problem, maybe it's not an uncurable title problem, but maybe it's just going to take a while. Maybe it's going to take 6 months. Maybe it's going to take 9 months, a year. And C says, you know what? I don't want to do this deal. I'm not waiting that long. I got other opportunities. I'm moving on. Well, if there's not any type of clear indication as to, well, then if you terminate C, what happens to the original agreement of sale, right? So what we're trying to do is set up a structure where C can terminate, and it's very clear that B then has the rights under the purchase and sale agreement. So that's not just clear between B and C, but if A knows about what's going on, now B can go back to A and say, okay, look, I'm back in the game here. This is my contract. I'm either going to close on it, or maybe I'll work with someone else and assign this to someone else, whatever the case is. But B has not only a clear understanding with C, but hopefully also now with A as far as what's going to happen. All right, so let's move on to Section 3. So conceptually, Section 3 just says that all of the terms of the deal are in this paper agreement. There's not other stuff in emails or handshakes or verbal conversations or whatever the case is, that it's all included in this agreement. That's important. You really don't want extraneous terms sitting out there anywhere else. If it's a term, if it's something you want, if it's something the other party wants and you guys agree to it, put it in the agreement, right? You do have a responsibility to make sure that all the terms and conditions are captured in this agreement. And if you have any doubt about that, talk to your attorney. This document can be edited, and it should always be reviewed anyway and edited with your attorney to the extent that there's anything that needs to be amended. Okay, Section 4, governing law. Pretty straightforward, just says Delaware law is going to govern this agreement. I don't think there's anything controversial there. Section 5, the counterparts section, says that not everyone needs to sign the same physical sheet of paper, right? One party could sign one sheet of paper and the other party could sign the other sheet of paper. But I would recommend at some point that either you as the assignee or the assignor, whoever, whichever party is going to take that responsibility, aggregates the fully executed, assembled version of this document, meaning, take the pages of text, take each of the signature pages, take the purchase and sale agreement that's being attached as an exhibit, put them all together, scan them all in, put them in one PDF, and email it out to all the parties in the deal and say, here's the fully executed, assembled version of the assignment of the purchase and sale agreement, so that it's clear to everyone, which version, which documents are included and aren't included, less issues down the road. All right, Section 6, severability. So what we're saying here is if a court invalidates one provision in this agreement, it's not going to invalidate the entire agreement. It's only going to invalidate that provision, and the rest of the agreement is still enforceable. Right? And I think that's what you would want. You don't want the entire agreement being potentially thrown out because there's one provision that doesn't hold up for some reason. Okay, Section 7, the representations. So the assignor has made no material representations or omissions with respect to the condition of the property. We also have some entity representations here, and then we have a survival clause at the end saying that the representations in this provision are going to survive. So what we're just trying to do here is build in an understanding between the parties that basically everybody has conveyed what's known about this property, and that it's in everybody's best interest to just communicate whatever's known. Now, technically, the seller in an assignment deal is the party that really knows what's going on with the property, and the seller should provide a seller's disclosure, and that seller's disclosure should be passed along from B to C so that the ultimate buyer knows what he or she's getting involved in. So Section 8 is the indemnity provision, and this is an important provision. So here it says the assignee is going to indemnify and hold harmless the assignor, and you really want this provision so that if the assignor is damaged in some way, now this could be, let's play this out. Let's say C defaults, doesn't close. Now let's say A, the seller, sues B and sues B for $25,000 because let's say the seller had to turn around and fire sale the property to someone else for less and lost $25,000. And now they come after B. Now B ought to want to have recourse against C, right? Because C defaulted. C is the one that caused B's trouble. C was supposed to close, C didn't close, and now B is getting sued, right? This provision says that B can now go to C and say, okay, you are going to reimburse me for my losses, which, seems like a reasonable situation for me, but it's certainly something you want if you are the assignor. Section 9, time is of the essence. It says that the dates in this agreement are of the essence, and that's important in a real estate transaction because otherwise the dates are generally construed as just sort of estimates or aspirational in many cases. Attorney's fees. So you want to have a provision, we're in section 10 here, so you want to have a provision that says if one party breaches, the other party can get attorney's fees and expenses for enforcing the agreement. And that gives that party who's trying to enforce, the non-breaching party, it gives that party a little bit more to work with, gives them a little bit more leverage. Because if they win, they not only get reimbursed, let's say go back to our scenario where there's the $25,000 loss, right? Then not only can B get the $25,000 back, but B can get attorney's fees back for coming after C to reimburse him or her for the $25,000. Or in the case of the $40,000 assignment fee example, right, where C just defaults and maybe B doesn't get sued by A, but B lost the $40,000 in profits, B can go after C for the $40,000 in profits, but also the attorney's fees and expenses for having to go after C, which now is much more attractive to B and is much worse for C because now C is going to have to pay C's attorney's fees and expenses to defend the lawsuit, but now may also have to pay B's attorney's fees and expenses and the $40,000, right? So sometimes that leverage dynamic can be used to keep a C at the table, where maybe B gets an inkling that C's thinking about walking, and B can say, hey, you better not walk because this is what's going to happen. Okay, 11, sealed instrument. So a sealed instrument in Delaware, it does not mean the document's notarized. What it means is that there doesn't need to be consideration for the agreement, and also that the statute of limitations is extended from 3 years to 20 years. So that's a benefit for really potentially both parties, but here probably more the assignor. Okay, the next page is the signature page. And you'll notice we have, for the assignor, we have a signature block that's designed to be for an entity, where again, you're going to fill in the company name. If your company's an LLC and it has an LLC designator at the end of it, then you'll just leave that in there and write in the other part of the company name on the line before the LLC. If it's a Delaware limited liability company, it's already set up for you. You don't have to worry about that. Where it says by : then you're going to sign your name on that line. And then underneath that signature line where it says name : you're going to print or type your name. Underneath that where it says title : you will print or type your title. This is your capacity. If you're a member of the LLC, if you're manager of the LLC, if you're president of the corporation, Again, you got to amend the other part of the signature block for it being a corporation, but you can certainly do that. But you always want to include your capacity when you are acting on behalf of a company. It is critical that you do that. As far as the assignee, same thing, except we're not making necessarily assumptions about what kind of an entity it is. So that would have to be filled in, but in similar fashion to how it is for the assignor. Now you'll notice that to the left of the signature blocks, there are witness lines. So witnesses are not required, but they are recommended. They're recommended because it's then harder for the party signing to say that they didn't sign if there's a witness that says that they signed the agreement. Now, it's always better to have some idea who that witness was. So if you could have the person print their name underneath their signature, that would be ideal. But witnesses do help. Now, you could have the document notarized as well if you would like to. It kind of ramps up the witness aspect a little bit more when it is a notarization. The document's not set up for that, but it certainly could be done that way. Now, another note, if you have an individual signing and you want the 20-year statute of limitations, if you want the no consideration from Section 11 sealed instrument to be effective, then you need to type the word seal after their signature. Now, you got to have it on there before they sign, but it's got to be on that signature line. So you would put a parenthesis and then put on all caps SEAL and then close parens, which is the other side of the parentheses. And that is going to be on the signature line. You need that if it is an individual. If you have companies signing, then all you need is the declaration in Section 11 to make a sealed instrument. So that is it for our video on the assignment of purchase and sale agreements. I hope you found it helpful. Please kindly take a look at our other videos that we have and hit the like and subscribe button so we can keep bringing you valuable and profitable content. With that said, thanks for watching, and I'll see you next time.